Stay tuned to meet Advocate Capital client Terry Jackson of Terry D. Jackson PC. Terry, you actually began your career as a certified public accountant and then later went to law school and became a trial lawyer. And I'd like to ask you today, how has your background as an accountant influenced your decision to work with Advocate Capital?
Sure. Any business, I don't know if you're large or if you're small, at some point during the course of your practice, you're going to need leverage to amplify your case, to amplify your practice, or just take some of the pressures off. As plaintiffs lawyers, we work on a contingency basis. Cash flow can be sporadic at times. We all go through that, and even the biggest and most successful lawyers. So if you're watching and you're a sole practitioner or a small firm, don't fool yourself that you're in that boat alone. You're not. We all go through this. And it's just time value of money, smart business principles. And when I say educated risk, if you believe in yourself, you believe in your clients, and you believe in the case, but you're in a spot where you can't fund it, you need some help, and you may want to associate, but if you want to keep the case yourself, it allows you to leverage what you put in all these years, the education, your experience, and a great case and a great client. It allows you to go into the market, borrow the funds, attribute the costs and the interest from the borrowings to a particular client. And in my experience, it works out well. It allows you to have contain or cabin your cost to a particular case, and allows you to keep track and assess your level of risk. We all have level of risk that we're willing to take. I'm a risk taker, but I, like anyone else, have my threshold of pain. And as a lawyer, that comes in the amount of money that you're putting in your cases. So it allows you to track, it allows you to be apprised, but it also candidly gives you the freedom to do what you do best. Think about your case, understand the facts, the law, and push your client's case to trial, because that's, as trial lawyers, that's what it's all about, is trying cases, not shuffling papers on your desk, hoping that somebody's going to bestow a settlement on you at some point.
Exactly. From time to time, Terry, when we are speaking with prospective lawyers who are considering using the Advocate Capital program, we hear, I don't need the money. And so they've been self-funding for a while. And again, as an experienced trial lawyer and as an accountant, if you heard one of your peers say, I don't need the money, how might you respond to them?
That's doesn't make much sense. That would be an argument if I were on the other side of them as a trial lawyer to be able to pick apart. And it's really just a variable analysis. If you're getting charged X percentage to fund your client's case, and you're able to deduct that interest or pass it on to your clients, and in return that frees up funds where maybe you self-fund other cases. I do a mixture. I self-fund some and I borrow for others. It allows you the freedom to free up your money, and it's really that simple. If you don't want to self-fund your own cases, if you want to, you got a cousin or a brother-in-law or a neighbor that manages money, take your money and put it with them and earn interest on it and pass on the risk of the case to your clients. And as long as I find clients to be fine with that. If you're upfront and you say, look, you've got a great case, it's going to be expensive. It's going to be a couple $100,000, maybe $500,000. I've had cases where I get close to $1 million in them. And you explain to them that you may have to borrow funds. These are rates, they're lines of credit. They're understanding of that. But you also don't want to put yourself in the position to be leveraged. If you're self-funding your cases and you go through a dry spell, or you're not getting to trial as quickly as you can, and you need the money. You're running a family and you're running a business. Most lawyers are. You don't want to put yourself in a position where you're having to resolve cases or take less than value because you put yourself in a position to be leveraged as a lawyer. That's not good for you, and it's not good for your clients in the case, because your clients want justice. They don't want discount justice, and they don't want self-funded leverage justice.
Absolutely. That you touched on it just a little bit. And one of the other things that we hear from time to time from prospective clients is they're concerned about the impact that borrowing will have on their client's case. What has been your experience? What is the real impact to the client, if any? And do you get objection from time to time?
I've received no objection yet, but I'm sure it's coming, but it's an issue. I think it will only become an issue where you have large cases, large interest cost. If you had a case for $500,000, 500,000, and you're carrying it for a couple of years, the interest can be significant. Even then, if you're successful and you believe in your case, you believe in your client, you believe in yourself, and you get the right result, clients are not going to complain. I think the danger may come is if you have a lot invested in a case, the interest carrying charges are high, and the outcome isn't what you expect, then you may have to, and that's just a business decision. You may have to cut some of the interest costs and eat them yourself in the case, because you're the one taking educated risks. Your clients are relying on you, they trust in you, and they believe in you. And you sometimes have to be self-aware enough that if you didn't get the result, you may have to take a haircut on some of the carrying costs for the interest. And that's just part of being in business.
Absolutely. Well, thank you so much for joining us today and sharing a little bit about your experience with Advocate Capital. We appreciate you and the important work that you do every single day.
Terrific. I appreciate it, Donna.